Uh, Good morning, good afternoon, depending on wherever you may be located. For those who are not lucky enough to be in Paris, you're not missing much because it's the 1st of April and it's actually snowing. So a great April Fool's Day for those of us who are Parisians. Welcome to all of you. Today, we're going to be dealing with the European Commission's proposal for a directive on corporate sustainability due diligence that was published on the 23rd of February 2022. As you may have heard, the aim of the proposed directive is to foster sustainable and responsible behavior of businesses that operate across the European Union throughout their global value chain. And in particular, it will force businesses to identify, prevent, mitigate, and remediate the adverse impacts of their activities on human rights and environment in Europe, but also beyond. Obviously, this is just a proposal for the directive. So I suspect this text will be amended, but in light of the current developments dealing in particular with access to energy, human rights, climate change, that are indeed most fundamental subjects to be tackled rapidly and adequately. Of course, this proposed directive will be most interesting, as it will create a certain number of obligations for businesses for the years to come. To discuss this project, I have invited one of the most qualified speakers I believe we can have, that is to say, Noël Lenoir, who's well known by the French public. Noël Lenoir is especially well known for holding several high-ranking positions in the public sphere in France. Most notably, she was the first woman ever appointed to the Conseil constitutionnel, the French constitutional court. She was the first woman, and I think she remains to this day the youngest member who had been appointed at that time, and she served as a member of the Conseil constitutionnel from 1992 until 2001. She was then the Minister of European Affairs between 2002 and 2004 under the presidency of President Jacques Chirac. She's held other political positions. She was a mayor at some stage. She had many roles in the academic and business worlds. She was a member of the French Conseil d'État. She was also the ethics minister of the Assemblée nationale, the French National Assembly. So she knows the public sphere extremely well, and in her capacity of French Minister for European Affairs, I have no doubt that Noël knows the intricacies of the relationship with the European Commission, so there will be a very interesting view. Noël has also taught biotechnological law and ethics and European law at Columbia Law School in the United States. She also held, and of course, I'm not going to run through the whole biography of Noël, because we only have 1 hour and 15 minutes. So it'd be nice if we could start a webinar as well. So I'll be brief on the biographical aspects. But Noël has also been in private practice as a lawyer. She was with several premier US law firms, including Debevoise and Plimpton. In 2020, she started her own firm, Noël Lenoir Avocat, where she handles, among other things, constitutional law, indeed, as a reminder that she was a member of the French Conseil constitutionnel, public law, competition law, data protection, compliance, and ESG issues, as well as corruption issues. I'll put an end to the biographical presentation. It's incomplete, Noël. I'm very sorry about this, but I think it's better if we hear from you about this proposed directive on corporate sustainability that was just proposed by the European Commission. The way it's going to work, Noël is going to present for about 45 minutes, and then we'll have about a half hour for a Q&A, and you can put your questions in the chat as you go along. So Noël, the floor is all yours.
Thank you very much, Eliseo. I thank you warmly for your invitation. You said that I will be a good speaker. I don't think so, unfortunately, because my English is a bit French, my accent, and I'm not as fluent as you are, but I tried my best. I'm very flattered to be able to participate in this very prestigious event, the Arbitration Week. I think it's fantastic. I've seen what you have done and the program, and also listened to some of the interventions. And I thank you very much to have allowed me to choose my subject. And I think that some of you are perhaps a bit surprised by my choice, because you would think that it has not a direct relation with arbitration. I try prove the contrary, but also I think that more generally, the duty of vigilance, which is what it is about with this proposal of a directive by the Commission, that the duty of care be extended to the whole world, and with regard to human rights, social rights, and environment, is totally changing the perspective of corporate responsibility. It is really the way this responsibility, including accountability and liability, is becoming truly global. Globalization was mainly economic. Now it is social and ethical. And this is a sea change. I think that it concerns the entire world, the entire legal world, not only lawyers in-house and not in-house, but also arbitrators. So that is the reason of my choice, because we are living great changes for the best and the worst, as you can see, with regard to, unfortunately, the war in Ukraine, but with regard to the role of companies as economic operators, but also the civil society as a global actor challenging these companies. We are living the biggest change in law, I think, for decades. So I will go to the next slide, because I want to organize my presentation in three parts. First, what are the goals and the inspiration of this proposal? Second, what's the content? And as I said, the key idea is more responsibility for corporate companies, more accountability, and even more liability. And also, I will talk about why this text is not the end of the day, because it leaves it up to the states in Europe, but elsewhere, a great margin of appreciation of how to interpret this new obligation of social corporate and responsibility. There will be many discrepancies, in my view, even in this side of the world, that is to say, between the US and Europe. So first of all, this text doesn't come from nowhere. It has been a long reflection, which began to be open at the UN level in 2005. And it gave place to two main recommendations, declarations, which are still the reference of corporate social responsibility. First, and which were published the same year, 2011. First, the guiding principles of business and human rights of the UN, and second, the OECD guidelines for multinational enterprises. And both have the same ground, that is to say, to consider that companies are responsible for the impact of their activities with regard to human rights and environment, but also of the impact of the whole perimeter, if I may say so, of their economic partners, not only their subsidiaries, but including their suppliers. And that's why, you know, it's like, if I may use this expression, like a mother company is not only the mother of its subsidiaries, it's also the mother of its suppliers, because it has to take care of what they do and of their possible misconduct across the world. The second thing is that to that goal, that is to say, to obtain of corporate companies, especially multinationals, that they look at what is done on their behalf or with their suppliers across the world, there is another goal, which is really the hallmark of Europe, climate change, fight against climate change. And I will tell of this a bit later, but I want to underline here that because these principles are now recognized throughout the world, I mean, in democracies, corporate social responsibilities of companies, the European Union, after certain countries such as France, considered that it was time to go from soft law to hard law, because these guidelines of the UN and of the OECD are not binding, they are only guidelines. Tu le mets? Hop. What has triggered this decision to transform, if I may say so, these guidelines into hard law? Two events. First, the tragedy of the Rana Plaza that I think that everybody knows, I've heard of. It was a very, it's a tragedy. The Rana Plaza factory was a big building. It collapsed because the building was of poor safety standards. And there was hundreds of deaths of these young workers, women especially, in the garment industry. And the ordering companies were big stores and also the textile industry. So that's why this triggered politicians to do something, because the emotion in public opinion was huge. So the first law ever to have been adopted to transform the guidelines of the OECD and the UN into a law of binding force was a French law. If some of the participants of this seminar are French, they know that we are like a sort of socialist country. We think that capitalism is good, but it has to be controlled. And that's why France adopted the first law ever regarding the duty of vigilance in 2017. And this law is directly inspired by the OECD and UN guidelines in the way that its main purpose is to require companies to ensure that their subsidiary and suppliers across the world respect human rights and environmental rights. This is the first purpose, to make, in a way, capitalists responsible for what they do in having commercial relationship with economic partners. You know, it's not like money laundering, but a little bit in the way that you have to deal only with honest people. It's the same spirit. The second point is the Green Deal. The Green Deal is really, in my view, and sometimes personally speaking, because I'm free speech a bit too much, the Green Deal is the main, has been till now, after the Ukrainian war, has been till now the main political orientation of the European Union. And the European Union wanted to be, and still wants to be, at the forefront of the fight against climate change. I totally agree that fight against climate change is indispensable because human beings want to live as long as possible, and we don't want the planet to disappear or to be an hostile ecosystem for human beings. So I totally agree with the fight against climate change, but it gave place to an unprecedented arsenal of legislation in all matters. So I quote some of them, but you have many more. So you have the non-financial reporting directive, which is to be modified to reinforce this reporting. You have the sustainable finance disclosure regulation. You have the taxonomy, which is a sort of classification by the EU Commission of the virtuous activities, durable, sustainable activities versus not durable, sustainable activities. As you have seen that recently, the German obtained to include gas, fossil energy in the taxonomy, and the French obtained to include nuclear energy. But very important because if an activity is not mentioned in the taxonomy, very difficult for a bank to fund, or for a fund to finance this activity. You have the eco-design directive, a big scandal, because there was a proposal by the Commission to exclude defense industry. I don't know where we are now, but there's many discussion, and environmental liability directive. I don't quote many other proposals of the Commission, such as a directive on criminal law and the environment. So this is the context. And of course, this directive is part of this arsenal of legislation, but on a more general level. So now the content of the directive. So the goal is companies have responsibility, and they have to have commercial relationship only with people who all over the world are able to be compliant with human rights protection and environmental protection. And if not, they don't have to have this relationship, or they will be punished. This is the idea. And it's also a tool to accelerate the transition strategy of corporate companies, of European corporate companies, so to allow the European Union to be the first in the world to have been efficient to attain this goal. The content. First, the scope. Two kinds of companies are concerned. The first are the companies subject to the duty of vigilance. The parent companies for their subsidiaries and the ordering companies for their suppliers. The proposed directive mentions 30,000 EU companies. I don't know. I just compare with the French. The threshold retained by the French law to designate the companies which are subject to the duty of vigilance is 5,000 or 10,000 employees at the level of the group worldwide. It represents about 250 companies or 300 companies. With the European text, the European directive, you have around 3,000 companies, I think. So it's a sea change. So the threshold in Europe in the directive will be more than 500 employees and more than 150 million euros worldwide. And 3 sectors are considered as high-risk sectors: textile, clothing, agriculture and food, extraction of mineral resources, and the threshold are lower, 250 employees and more than 4 million euros. It will be for the French agricultural sector, which has great difficulties, really a new burden. And for the textile also, because you have small companies in this textile, and especially also in Italy, for instance, in Romania. So it will concern a lot of companies, perhaps more than, in my view, 13,000. Then, which are the companies to be, in a way, controlled by those who are subject to the duty of vigilance? As I said, the subsidiaries. So this is absolutely usual, I hope so. And it's not really new, but the suppliers. Because in fact, the real goal of the text was that you cannot close your eyes on the practices of the suppliers, because these suppliers are in low-cost countries where our standards of protection of human rights are not at all at the level of ours. So it's to fight against what we could call industrial tourism. So that you go to low-cost country because you don't pay the people as much as in your country. And in addition, you are not obliged to respect the rights which are recognized to your workers or to your partners in your country. So this is the idea. And how to do this? Because I must say that it will be a fantastic burden, as it is right now for the French companies. Because as you know, the big multinationals have thousands and thousands of suppliers. Some of them have 100 and more than 100,000 suppliers, so a bit difficult. So the first consequence is to give an extensive room to the compliance department of the companies. They will do it either in-house, like the banks. You know that big banks, for instance, they have 3 times as much compliance officers as legal, the big banks. Because for banks, it's incredible. It will continue. I don't know if it is efficient, but this is how it works. And so due diligence will be the norm. And the directive considers that it has to be done every 12 months. So for instance, if you are Airbus and your supplier is Safran, so Safran is a big company, it is also subject to the duty of vigilance law, so you have to audit Safran every 12 months. So I think that sometimes this text, I wonder if this text hasn't been written by the audit firms, because it will give them a new a new business, very important one. So how to do this audit is another issue, and big companies are used to that, but it's very costly. The proposed directive doesn't define very precisely the kind of suppliers which are to be controlled, audited by the group subject to the duty of vigilance. It mentions the criterion which is used in the French legislation, that is to say, established business relationship. In France, it means nothing, because the case law is very diverse, very divergent. Sometimes it mentions company when you launch a tender offer. Sometimes it concerned only very big suppliers. In Germany, it's more precise. It concerns first-tier suppliers only. It can concern also the suppliers of other tier, second or third tier, only if the company has been made aware, has proved that the supplier has committed an offense or is badly as a misconduct, And in that case, the company, the German company, the German law is not yet applicable. It will be applicable implemented in 2023, but yet it exists. And I think that I would have preferred to limit the scope of the duty of vigilance to first-tier suppliers with the same system as provided for by German law. That is to say, you cannot have a willful blindness if you are aware that amongst your suppliers, not first-tier suppliers, there is something which is wrong. But I think that the NGOs didn't like the German system, so they obtained that the French one was adopted by the Commission. Then, as I said in introduction, the main goal is corporate responsibility. And responsibility, I like the English, because sometimes it's more subtle than French. In French, you have one word, responsibility. It can be legal, it can be ethical, it can be moral. In English, you have three words, as far as I understand English. Responsibility is generic. You have accountability and liability in court. So the first pillar, which is reflected by the proposal of directive, is accountability. And accountability means that means transparency. First of all, the company has to ensure that it respects international treaties. And in annex to the directive, you have quite a lot of international treaties, the International Labour Organization, the United Nations. Most of these treaties are not ratified by the US, for instance. I think of the Pact of the UN of 1966 on economic and social rights, they are not. So you have a lot of treaties. And what is entirely new, in my view, as a lawyer, is that usually, as you know, the treaties are binding for states, not directly to, and even European law, except in competition law, is not directly applicable to the persons, legal or individual. In that case, the treaties become law for the companies, subject to the duty of vigilance. So this is quite new. And this is how you can testify of the goal of the NGOs, which is to transform soft law into hard law through the treaties, which are, by definition, not very precise. Because when you say that you respect human rights, you respect the right of information, you respect the right of the indigenous people, you respect this and this, they are mostly values rather than provisions as precise as in a law. So this is a very, very large frame of reference. Second, based on this frame of reference, and without till now any guidance, companies, as it is the case in France, European companies, and not only French companies, will be obliged to publish their program of vigilance plan. In France, they are obliged to publish it in their report of activity, but mainly they do it on the internet. Anyway, it's on the internet. Here it's on the internet. But what is to be known? And not enough corporate companies in France pay attention to this. And in a way, I think it's really very interesting in this text. All what is mentioned in the plan is a legal commitment, which means that the plan includes measures taken for the company to fight against climate change, to ensure that human rights are respected where they operate or where operate their suppliers. They ensure that they have a map, risk mapping, etc., etc., a whistleblower system, etc., and it works. They also have to indicate how these measures have been implemented, what remedy has been given to the breach of rights that they have noticed in their subsidiaries or with their subsidiaries or suppliers. And they have also to appreciate the efficiency of the measures. And this, again, is very good for audit firms, which have now, because of this, of the French law, and tomorrow, because of this text, a huge business development at stake. So one of the recent consequence of the French law has been litigation, legal action brought against a big company. I don't want to name these companies because I work for some of them, so I don't, sorry. Greenwashing. Because if you say, for instance, and it has been observed, there are press articles on this, that you have totally stopped financing fossil industry. You have still investment, if you are an asset management company, for instance, you have still investment in the coal industry, but you will never finance new projects in this sector. And an NGO or anybody else identify that it is untrue based on the duty of vigilance, because you have announced this commitment in your vigilance plan, you can be sued. And this is not civil liability, it's criminal liability. So you see, this text has a different way of interpretation and can be the ground of different kinds of legal actions. Then you have the liability. That is how these companies are going to be punished. There are two systems. One is directly inspired by the German law. because the German law, which is dated June 2021, provides for the supervision of companies subject to the duty of vigilance by an administrative authority, which, by the way, is an office of the Ministry of Finance, the Credit Export Office Bureau, which you can think is rather not against companies. And the main, in the German law, the main duty of this service, of this bureau, is to guide the companies so that they have some idea of how to write a vigilance plan. But here it's more ambitious, because the system which is put in place looks very much like the system of data protection supervisory authorities in two respects. First, they will gather in a European network, a European committee, and second, they will have extensive powers, request information, carry out investigation, order to take remedies, trigger civil liability or criminal liability, because I mentioned civil liability, but criminal liability also, and inflict by themselves pecuniary sanctions compulsorily based on the company turnover. So it can be, in some countries, it will be 10%, in others 4%, in others it can be 30%, I don't know. So it's a huge power. I have mixed appreciation of this system, which has been originally fostered by the Americans on their model. And now I think that sometimes, at least in France, these authorities have really a punitive, especially punitive mindset. And sometimes they don't know very well what is a company and how to manage a company, I must say, but that's how it works. The second, so this is inspired by the German law, but in a much more extensive way. The second and more important, in my view, types of provisions are those who provide for civil liability for failure to comply with the duty of vigilance when there is a damage. But this has been, the consequence is twofold. First of all, it is mentioned in the directive that the applicable law will be principally the law of registration of the group in one of the 27 EU member states, and not the law of the country where the damage materialized. Usually, as you know, the applicable law is a local law. Here, it will be the law of the member states. And this is one of the purposes. That is to say that the company cannot take advantage of the fact that she operates or its suppliers, it operates or its suppliers operate in a country where you don't have to respect in principle the same value and standards of protection of individuals and companies as you have in Europe. And the second consequence is that the judge will have a role which will be very extensive, because it will have to apply the local law, the national law of the EU member state concerned, and treaties, because the framework of reference is made of treaties. So what will he do, for instance, or she do? For instance, in France, the judge has the duty, the obligation to put aside a law which is not in accordance with the treaty. So you'll have, through this text, the possibility of judge-made law in an unprecedented way. So this must be, in my view, a matter of reflection. Then I come to the end of this too long presentation. I want to insist on case law to show you that, in fact, this proposed directive is a compromise between different countries. Some were very pushing in view of having a law like the French one, and some others a much more less constraining law like the German one. So that's how the most important provisions are left to the decision of the member states to decide what they should be in transposing, in introducing the directive into their national, their domestic law. For instance, I take the example, I know that Eliseo has looked very closely to Article 15 of the text. It says that all companies subject to the duty of vigilance shall adapt their strategy, their business model to the Paris Agreement objectives. That is to say 1.5 degrees Celsius in 2030 and 0 and neutral carbon in 2050. How a judge will be able to know, even with experts, if the strategy is appropriate. You imagine the judge should do when you read, as I did, the submissions issued by certain NGOs against companies accused of lack of climate change fight or measures against climate change. You are struck by the references of dozens and dozens of reports of experts, which are understandable for myself, I think for most of the judges, and that leads the judge to have to assess scientific elements in disputes, which are so complex that my view is that they should logically go to arbitration, much more so than the judge. But the idea of the NGOs, as I will tell, is that the courts should have their say, because judgments and rulings are public and arbitration is not. But you know that it is really, it changes totally and for longer or forever the role of the judge in the economic sphere and human rights. So this is illustrated by two cases. One has to do with the Paris Agreement without any legislation in the Netherlands translating this agreement into law. It is a Royal Dutch Shell decision ruling of the Hague District Court, which ordered Shell to reduce its global carbon emission from its 2019 levels by 45% by 2030. So the judge considered that Shell was not in line with the Paris Agreement, but there was nothing between the Paris Agreement and the judgment. and it refers to the submission of the NGOs. And this, in my view, means is, as I said, is a matter of concern. And then you have the ongoing injunction for the same reasons, with the same arguments against Total Energy. But in that case, you have French legislation in between. But it doesn't change much. So you see that it is judicialization of economic goals and environmental goals, and the judge is asked to interfere directly in the management of the company. Then, with regard to the civil liability regime, for sure the directive will oblige, if it doesn't exist, as it is in France, the member states to define what will be the liability regime with regard to breaches of damages caused by breaches of the duty of vigilance. But this regime, that there has never been, except for defectuous products, this regime is very, very diverse, even divergent. From the admissibility of appeals, for instance, in France, any NGO, any association, any local authority, union, etc., they can, on their own behalf, sue a company if they think that the company doesn't act, doesn't comply with the cause that they defend, human rights, environment, etc. In Germany, they cannot. In the same way, there is a big pressure in France to introduce a presumption of liability. So insofar as a company have suppliers in a country where you have an authoritarian regime with no protection of human rights, there is a presumption of responsibility of the company, which means that, and it is a big pressure of the Socialist Party in France and also a member of the En Marche party, they made together a report of the National Assembly, and they asked for the presumption of responsibility. So if you have the onus on the proof on the shoulder of the claimants or on the shoulder of the company, it's a totally different regime of liability. To finish with, I think that perhaps I'm too long, so I will switch.
It's fine, Noel. You have take your time.
You think so?
Yeah, take your time.
Well, I have two slides. So this one is extraterritoriality, because as you know, the companies are not against some of them, but most of them, assuming their responsibility, but they say, well, if we are obliged to do this and this, what about the companies of the rest of the world? So the Americans, because the Americans have a system which is very simple, they say, with regard to corruption, with regard to embargoes, with regard to competition, they say, we will look at what the companies do across the world, because we have very restrictive and constraining legislation, and through the DOJ or the SEC, we'll take care that the rest of the world, the companies of the world respect our standards. I respect this. As you know, there are a lot of DPAs based on this idea of extraterritoriality. But the Europeans are not very eager to copy this trend. I don't know why. Perhaps they feel weak, they feel measure of coercion, I don't know, but they don't they don't practice except in the criminal sphere, where by definition, criminal law is extraterritorial, but otherwise they don't practice this. So there was a reflection at the level of the Commission to know whether third country companies should be or not subject to the duty of vigilance. So there is a beginning of extraterritoriality, but frankly speaking, I've read the directive many times and I don't understand what they mean by extraterritoriality, because there is a provision which states that the directive will be applicable to third countries company that reach a similar turnover threshold, that is to say 150 million euros, or in 3 sectors, 40 million euros turnover in Europe, within the union market. But to what extent will they be subject to the duty of vigilance? Because take the example, I don't know, of General Electric or Apple or another American company or Cisco. They have a turnover of 150 million in Europe. Do you think that the group in US will publish on the internet a vigilance plan? Do you think that they will accept to be recognized liable for misconduct of their suppliers in Tanzania or in Congo? I don't think so. And in addition, they are not going to accept that they should refer to international treaties that they have not ratified. For instance, the US has not ratified the Pact of the UN on socio-economic rights, as I said, because it's not their conception of the world. They are not a welfare state, as we are in France. They don't want it. You think that they will accept to refer to this pact through the duty of vigilance directive? I don't think so. So I think that the extraterritoriality of the directive is a little bit like greenwashing. It is vigilance washing. It is extraterritoriality washing. So there is no clarification at all in this text. And in addition, there is Article 25 of the directive, which extends the duty of care in the classical meaning of the term in US law, for instance, to corporate directors when the corporation is convicted of a breach of duty of vigilance with regard to the environment, human rights, and social rights at the suppliers level or subsidiaries level. They shall be subject to civil liability for breach of duty of care, but not foreign companies. So I'm sure that in this seminar there are very prominent lawyers. If they explain to me how this extraterritorial dimension of the directive, which is mentioned in the text, will really be implemented, I will be happy. Because when you look at the US case law and the famous, I think that everyone knows, the Kyobel 2013 against Shell, where a Nigerian refugee sued Shell in the US, considering that Shell allegedly was accomplice of the oppression by the Nigerian government, and the husband of this poor woman had been hanged by the government because he was an opponent. And this woman considered that her lawyers brought the case to the Supreme Court, but the Supreme Court unanimously said there is no link with the US, so this case is not admissible because, as said by the ruling of the court, extraterritoriality must not be presumed. It must not be presumed. There is a more recent case, I must say, in 2016, where in Iraq, it's a case called Al-Shimari. It's not the Supreme Court, it's a circuit court. The court retained that the contractor of the US military, which torture people in Iraq, the company was US and the employees also. The court admitted its competence, its jurisdiction, but it's not like with the FCPA, where the link with the US can be quite remote. Here, there must be a very close link with the US to accept that the company may be accomplice of certain misdemeanor in foreign countries where its suppliers are operated. So the last one, and you must say that at last I come to the subject matter of this week, Arbitration Week. So at first glance, you would say that arbitration is not at all concerned by this text, but all lawyers are concerned and all citizens are concerned, but not arbiters. I don't think so. Yes, it is true that the main goal of NGOs is to brought to court the companies because it is public and they prefer publicity of a trial to the confidentiality of arbitration. And to testify is that most of the submissions of these NGOs are published by the NGOs on their website. So the name and shame is a strong driving force of this directive and of the NGOs and of the French law. And as you see, even the day before yesterday, I only quote the legal actions, but you have, other kind of challenges of companies. You have Casino, EDF, McDonald's France, Suez, Téléperformance, Total Energy. I'm sorry, I put Total, it's Total Energy, XPO Logistic, Yves Rocher, etc. All of these companies are before courts for having breached the Paris Agreement, for employing workers in remote countries without respecting their workers' rights, for having industrial projects where not only the environment, but the rights of the indigenous people are not respected, etc., etc. And even, last but not least, as you have seen, companies are challenged before courts because of their investment in Russia, where they are, based on the duty of vigilance French law, accused of being accomplice of crimes, war crimes. So the inventivity of lawyers is without limit, as you see, and this law and the future directive can be the ground of many kinds of litigation and disputes. But my view is, because of this legal risk, which are unprecedented in legal economic in the corporate law, my view, it's a new world, and a new world where your reputation can be spoiled in 1 minute, and then it's too late. And this is what it is about. there is place for, there is room, sorry, for arbitration at different level. So I'm sorry, I'm not a specialist of arbitration. I would like to be, but I'm not. I think that Eliseo must have, he gave me one idea. He certainly has other ideas, but I think that first, in the relationship with between the company and its supplier, I think that there is room for arbitration clauses. First, in the event, in case the company is civilly condemned and then turns against its supplier, and both would prefer arbitration if they have sufficient money, rather than a trial which will give a new publicity to the misconduct of the company and of its supplier. So I think it's really one example that I think is good. The second example is, for instance, a company carries out due diligence and discovers that the supplier puts the company at risk before it is not compliant with environment duties, etc. Then there is a breach of commercial relations, and I think that the supplier, as is usually the case, would try to sue the company for damages, and I think it could be the subject of a commercial arbitration clause. In addition, I've seen recently that there are arbitration clauses with regard to workers' rights between brands and the workers of their suppliers. Following the Rana Plaza collapse, trade unions and some NGOs have worked with these brands, like Auchan, etc., to establish corporate accountability for workers' rights in brand international supply chain. And some NGOs have even published model clauses of arbitration. So I think it's a new. And the last example, which have been suggested by Eliseo, is the M&A dispute, the post-M&A dispute. Of course, everyone here knows perfectly well what it is about, but legal compliance, duty of vigilance compliance will become at the center of the guarantees that are to be subject to arbitration clauses. And I think it's a huge new field for good arbiters and for arbiters in general. So to conclude, as a lawyer, what to think of this? There is an extended field of practice. And even if you are at the end of the chain, that is to say, a litigator or an arbiter, you have to know more and more what it is about to manage corporate social responsibility risks. This really, I think this is a bridge between those the practicing lawyers who are specialized in advising, and the litigators and arbitrators. And also, as a citizen of the world, and as a former, as you said, civil servant and politician, I wonder what is the meaning of this new trend, and if it is always a valid gamble to put the burden of the necessary virtuous progress towards democracy and human rights across the world so much on companies, and especially on EU companies, as outlined on this directive. And I fear, as we discussed together recently, Eliseo, that it is that it reflects the weakening of the nation states and of politics and of geopolitics. And I think it's not good news, because we need to have, apart from the lawyers being arbitrators, and other arbitration, that is to say a nation state, which represents all the currents of the civil society, instead of having the civil society as complainant and the economic sector as defendant. I'm not sure it's good for lawyers. I'm not sure it's good for democracy all the time, even though I recognize that fight against climate change and fight for respect of human rights and the role of NGOs cannot be criticized in that respect. So thank you very much.
Thank you, Noel. I think you can close your slides if you want.
Yes, tu sais faire. Attends. Yes.
Otherwise, it's okay. Thank you so much for this very interesting presentation. I think one of the, unless someone has a question in the chat, and do not be shy for those in attendance. I see two people are raising their hands. Okay. Okay. So if people, yeah, we have a question in the chat, which actually was just a meeting of the greatest minds. I don't know, Anna Isernia Dahlgren, but you and I have a meeting of the minds. She's asking, this is just a proposal now. How likely do you think it is for it to pass? And I think the general context of the question is, the directive has been elaborated. And by the way, I'd be interested to know, first of all, how we came to this draft that we have today, and then what's going to happen next up until the directive comes into effect, and the states have the obligation to translate the directive into national law. I had read or heard that it would come into effect in 2025, but more or less. But take us through what happened before to get to this text, and what will happen up until the directive becomes an obligation for the states to make it domestic law.
Okay, so this is really the usual process, but not so usual, because first of all, when a text is prepared by the Commission, because as you know, at EU level, the Commission has the monopoly of the initiative. That is to say, no government and neither the Parliament can propose a text. Why is it so? Because it's difficult to obtain a consensus. So the Commission is the only one. But in practice, and especially now, where the member states have gained a lot of powers, a text is only proposed if the Parliament and the government push ahead to have a text. So that is the case. The Parliament adopted in March 2021 a resolution led by the far left in France, but it was adopted to have a very ambitious text on the model of the French law. And then some countries, especially France, but others, were quite pushing, because member states have to deal with the civil society new representation through NGOs. So at first, Mr. Renders, Commissioner for Justice, was asked to draft the text. So in fact, he didn't draft the text. The draft was drafted by the DG Justice, because it has to do with civil liability. And what is unprecedented in the legislative history of the Union is that twice the text was rejected in total by the Commission, because all texts which are drafted by the services of the Commission are submitted to a committee called the Regulatory Committee, composed of experts. And these experts considered that the text was not correct, because the duty of vigilance was imposed to company which had 20 salaried people instead of 500. And also it was very, very pejorative and very it stigmatized a lot the companies. You know, it was an ideological text. So, and it was too vague. And it was rejected twice, which never existed before, to my knowledge. Then the text was drafted in fact by 2 DGs instead of 1, because Mr. Breton, the French Commissioner for Industry and Internal Market, was co-appointed to draft the text. So Renders, DG Justice, and Thomas Breton, DG Gros. So there was a balance between industrial interest and the interest of the civil society, if I may say so. And that's how this text was adopted by the Commission. The DG Gros is Internal Market and Industry. So it has already been a very controversial text, draft. What will happen now? What will happen now is that, well, I didn't got because there was, you know, the Commission, when it drafts text, it puts the draft proposal on the internet, and you have consultation, and some lawyers send their contribution, and companies, etc. I didn't mention that. It was done by the DG Justice before the drafting of the text. But I was a bit shocked, personally speaking, because the Commission asked think tanks, all British, only British, at the time of the Brexit, to look at the text. And it's a report which was published of, let's say, almost 400 pages. It's, well, I'm not very much, I'm a federalist, I'm a pro-European, but I'm a bit sad sometimes when I see how the Commission operates now to draft legislation. It's very difficult because you have to obtain the consensus of the majority of Parliament. It's very difficult, but sometimes I don't like the process. But what I'll say is that really it was a very controversial text from the very beginning of the process. Now, what is going to happen? The legislative process at the EU level is quite different from what it is at national level. That is to say, instead of having, well, when you have a bicameral system, you have the Senate and the Assembly, or the House of Representatives or the House of Commons. I don't speak of bicameral system. The two chambers, the two legislative chambers at EU level are the Council of Ministers, in that case, the Ministers of Justice, and the Parliament. They are equal. And they work in a separated way, so that the Parliament, they will have a reporter of the text and shadow reporters of each group. And then you'll have the Council of Ministers, and most of the time, the text of the Parliament is to be approved by the Council of Ministers, which has most of the time the last say. But it's very complicated because you don't have preparatory works as we have in other parliaments. There is no report. The parliamentary report is the text of the Commission and the amendments, but there is no debate, there is no explanation, there is nothing, because all the debates take place in the Commission at the committees level of the Parliament. So I think that there will be a lot of debate at the level of the Council of Ministers, because I know that the Scandinavian countries and to a certain extent the CDU, I don't know about the Social Democrat in Germany, are not very keen of the text. Others are. And, you know, some of the countries in Europe, such as Lithuania or Estonia, they have other concerns at the present time, I think, than this text, but they have not big multinationals, they have not big groups, so they are less concerned than we are. So it's a very political debate that already took place, and it will continue to be a very political debate. And of course, I spoke of two legislative chambers, the Council of Ministers and the Parliament, but you have a third legislative chambers, the lobbies. I'm sure that the lobbies, that is to say the groups of interest, you'll have industries, NGOs, lawyers, everybody. I'm not against lobbies when it is transparent, because I think that the legislator has to know what is the viewpoint of everyone. But I think that it will be a very harsh debate. And I regret that the text leaves to the countries to decide what should be the main provisions at the text, that is to say the civil liability regime, which means that there will be distortion of competition inside the union market between EU companies. I was too long.
So that's absolutely fine. Thank you. I just a small observation, because you referred earlier to the Green Deal in your slides, and I was, it's a process I followed at the time. I was somewhat surprised about the lack of coordination within the EU with respect to the elaboration of the Green Deal itself. And that shows actually from the fact that a few months after the Green Deal package was published, the European Environment Agency, which is an agency of the EU, made up of scientists, issued a report which is called actually Growth Without Economic Growth, that basically contradicts a lot of the parameters that appear in the Green Deal. So we have a political body saying something on the subject, and a scientific body of the European Union saying very politely but very clearly, we're not sure we agreed with what you just issued. And I think that's a problem. I see we have other questions in the chat. I see Pascal Akawi has raised her hand. I don't know if she wants to speak, and then I'll take a couple of other questions. Pascal?
On vous voit pas. We don't see you.
I see you raise your hand, Pascal, so I just allow you to speak. Okay. You're on mute, Pascal.
Sorry, it was by mistake. I'm so sorry.
Okay, so
yes. And thank you for this wonderful presentation. Thank you. Sorry, I'm listening.
Thank you. So I'll go back to so just okay. I'm just taking another question now, looking at the chat. And we won't have time to take them all, but feel free to take one if you see one of those that you want to take, but I want to take this one, I think. As regards to judicial decisions on reduction of the emissions of the companies, so I'm assuming this refers to greenhouse gases emissions, how to assess whether these decisions are later complied with? This is a question from Janina Vlasenko.
How do you ensure that it is respected?
Yeah, the reduction of emissions of the companies. How do you? how do you ensure that the judicial decisions on reduction of the emissions of the companies, so the companies have made a commitment, and there's been a judicial decision on this commitment probably because it was not met?
Well,
if I understand,
in this case,
probably the question.
Yeah, I think in this case, implementation and respect of the judicial decision is much more ensured than in other cases. First of all, because the company has to publish in its vigilance plan what has been done. Second, it has to be certified by auditing companies or others and verified, because there is the other directive which gives details of the extent to which this vigilance plan has to be precise, is the directive, the proposal of directive of April 2021, where you have KPIs and other kinds of information to be given, and it will be compulsorily certified by audit firms or certification companies. And then, as you can see, there is, for instance, in France, a document which is regularly updated called the radar of the duty of vigilance, where the NGOs, which are quite well equipped, have experts, have in-house lawyers, etc. They supervise this in a very close way. And for instance, yesterday, 300 NGOs gathered in a consortium published a report called Banking, Finance, Climate Chaos, mentioning what is done and giving details on the way the different financial banks and funds are involved in companies efficiently fighting against climate change. Never in history, companies in this field have been so closely controlled by the NGOs, by regulators, because you have, for instance, if I take the example of the financial sector, you have the SEC now, which has published a few days ago new guidelines on disclosure, which have, as you have the same in France with common guidelines of the equivalent of the French SEC and the supervisor of the banks and insurance companies. So I think that never in history you will have so much control on the energetic transition as we have right now, because you have, in addition to regulators, NGOs, which are really extremely well equipped, as I said, to ensure that the judgments are respected. Of course, you cannot ensure that it's done at 100%, but I think that the company cannot think that they have a judgment and they can they can do nothing.
Just a couple of comments, Noel, thank you. You referred to the SEC rules. I mean, there are proposed rules that have not been yet adopted of the 21st of March, and I don't know what the process will be, but those rules basically say in one of their provisions that if a company has declared that it will be net zero by 2030 or 2050, for example, it will need to report on its transition plan to do so in its financial statements. And also it will need to give details on its scope 1, scope 2, and scope 3 emissions. Scope 1 are your direct emissions of the business. Scope 2 is basically the purchased electricity that the business needs to run. And scope 3, which is actually the most difficult to assess because it's 90% of your emissions, is downstream and upstream, which is the emissions from your clients and the emissions from your suppliers. So that obviously will create quite a wave of litigation or claims in arbitration when you sell a company. And you also have other interesting developments. And I think Noel and I talked about this earlier this week. I think this week or last week, Client Earth, which is a well-known charity and NGO, they bought shares in Shell and sued the board of directors of Shell, saying, well, I'm acting as a shareholder. You're not taking enough action to meet the 1.5 target of the Paris Agreement. So this means that you will affect negatively the value of the shares. And I happen to be a shareholder, so I'm suing you as a shareholder. I'm suing the board of directors. So this is also an interesting development. Maybe we'll take. We're considerably out of time, but maybe we'll take another question before we wrap this up. And sorry, we don't have time to answer all of the questions, but
you'll give them to me.
Yeah. If there's a question you like in the chat, feel free to take it on, Noel.
I don't have the question.
Oh, it's in when you go the discuter in the chat, you see the question.
Ah, d'accord. Sorry.
So there's one.
Sorry. Investment treaty. I think so.
Yeah, I read the question so that the other people know about this. Miriam Elkara, do you think the increased responsibility of corporates with regards to sustainability calls for better protection under investment treaties?
Yeah, I think so. I think that in investment treaty, you have the criteria of discrimination and breach of the right of property, if I may say so. I am not a specialized, but I think that a foreign company which has dans les traités d'investissement, a foreign company. No, the discrimination is more for the EU companies. How would play the discrimination? I think that the foreign companies, with regard to the directive, they are not to criticize from the point of view of the directive. But for instance, if I take the example of a company in the oil industry, I don't name it, in Russia. And because it is a challenge, even though it has no contact with any sanctioned oligarch, and it is obliged to leave Russia and to lose all its money. Well, it's not the fault of because of a Russian NGO. No, I don't know. No. How do you see the treaty of investment concerned?
Actually, I think I'm going to be talking. I was going to say the competition, but it's not really the competition. But I spoke partly on the subject on Tuesday at an event organized by John's Day on compliance, corruption, climate change. Tuesday on John's Day. I'm sure John's Day will make available the recording on their website and LinkedIn probably at some stage. I mean, it's an issue that will be that will be popping up in investment treaties, in particular if states themselves have not done enough, for instance,
Okay.
about
No.
climate change, but certainly I think what's going to be at play, in my view, because of the pressure in particular to try to remain within the targets of the Paris Agreement, among other sustainability commitments, is that you're going to see a sort of a public policy sort of a public policy of a climate change law that will emerge, that against which investors will be, the protection of investors will be assessed. In other words, at some stage, the world is moving so fast that the legitimate expectations you had to a stable system before, I think, are not going to be that relevant in the future.
No.
And I think we're going to be driven maybe to legitimate expectations based on the best available science we have now, rather than an absolute protection of investments, because as far as temperatures increase very quickly and as social disruptions will arise, I think what we saw in terms of protection of investors before might not be exactly the same world we'll have tomorrow. I mean, it's to be seen, and it's a very interesting question. And I think the panorama will change compared to the prior cases we had.
But I forgot, Eliseo, but I think that we are over time. I forgot to mention the free trade agreements, because as you know, the new trend at the EU Commission level is to introduce in the free trade agreements commitment of the country with which you negotiate this agreement. And also in public procurement, there will be, through these free trade agreement, in public procurement procedure, you'll have the European Union want to introduce this dimension of climate change. Could give place to arbitration as well. Because imagine that you have a public procurement at international level, a transborder public procurement process. And the company doesn't obtain the deal just because it is considered as not having the right level of climate change strategy, or, you know, there could be a place for arbitration instead of a lawsuit, of a litigation. I don't know, perhaps.
I'm afraid we don't, at least I don't really have time. I have a commitment afterwards. I'm sorry about this. We had that scheduled an hour, 15 minutes, and we're well over 1 hour and a half. And I'm sorry not to be addressing other questions. I hope that the presentation was enlightening for everyone, even if the text might still change quite a bit before it's actually adopted. I'll have a takeaway that I see from your presentation. That you used a couple of expressions. You used the expression judge-made law. You talked about judiciarization of the economic and environmental goals, and you wondered in your conclusion whether it would be for businesses to assume what should actually be the task of, and judges to assume what should actually be the task of governments to make policy. And since you're referring to judge-made law as a constitutional lawyer, you are well aware of this idea of the government of judges that was not deemed necessarily the best body to design policy for society. And I remember in the course of because we're in the Green Deal era, but if we look back at the original New Deal with Franklin Delano Roosevelt, He had the whole Supreme Court against him in the 1930s. And he said just to, at that time, there were only gentlemen on the court. So he said, gentlemen, you know, if you keep striking down my New Deal, I'm just going to add one more judge on the court every time.
The packing.
I'm going to pack the court until the court is all on my side and I can make policy. But all joking aside, I think it's going to be whether we're talking about human rights, sustainability, or climate change. There's going to be an obligation for governments to step up and not just to say, well, companies, you have to be 1.5 compliant, deal with it, it's your problem. We're not going to give you directives in terms of what you're allowed to do, what you're not allowed to do. And if you don't do it properly, you'll be fully liable. I think there's a duty for governments to step up and to define policy so that we can meet the goals that are very, very, very difficult to reach. I'm very sorry again not to take any questions.
Thanks a lot. And I'm sorry for my English, which
it was great, actually.
And thank you very much indeed. And thank you for your invitation. And see you soon.
Thank you.
Those who want to ask a further question, perhaps they can join you. I don't know how. I would be happy to answer.
Sure.
If I can.
I'll drop the presentation on LinkedIn in a few days.
Okay.
Those who want to see it afterwards.
I will put Total Energy instead of Total because I forgot.
They'll be happy. Thank you so much, everyone. Have a nice weekend.
Thank you.
And bye for now.
Thank you very much. Bye-bye.
Bye.